record on this computer. All right, so we're recording now. Hopefully we're able to be seen by everyone. I'm just recording now, so we are live. For some reason, Zoom just looks a little different than what it normally does, but it seems to be recording, and we seem to be live. So here we go. Welcome to our webinar. Tech and lawyers usually don't mix very well, so we're lucky to be recording it all, really. Welcome to our webinar today. It's on interns and trainees, and I'm really excited to introduce you again, Carla Vinciulo, our workplace expert. Well over 10 years experience in workplace law now, loves workplace. That's all she's done her entire career. And the more that I've seen Carla helping out clients in this space, the more I realise how much there is, one, that I don't know, and obviously how much we have to learn. But as business owners, how important and how dangerous it is, and the ramifications and potential disruption and investigations and all that sort of stuff that can have major impact on your business. And of course, the key part of your business, which is staff. So yeah, the more I'm sort of starting to realise this, we see the importance, and we wanted to release quite a few webinars about various topics that we've found that clients are coming to us for, that are either they're stepping into a lot of hot water, or we can see that there's a lot of area of risk for them, and we wanted to kickstart this off with. We've done unfair dismissals, right, Carla, last time?
That's right.
And we'll do unlawful terminations and a few other sort of stuff that we know. We'll get some questions from clients, consistently asking us about this particular sort of topic. So we'll keep doing these for you to provide you with as much legal information as possible. So yeah, that leads me into the next point in terms of the in terms of our disclaimer, our usual disclaimer. This is for informational purposes only. It's not to be taken as legal advice. And look, every situation is unique. Every particular employment situation is unique, even down to the industry and the experience of every particular employee, which you need to, as a matter of course, get some sort of advice about, to make sure that you're complying with the law. If you have any specific questions as a result of this webinar, give us a buzz. We're here to help you. So Carla and I are available to talk to you about this stuff in order to make sure that you're protected, because that's what we're all about. Let me just do the slideshow here. Can you see that now, or can you see the slideshow?
Not as yet.
Okay, let me just share my screen here. Zoom. It seems so different now. Speaker view. Share screen. Okay. Now we should have it.
Yes, beautiful.
Okay, cool. That should be working now. All right, so we're going to keep this to half an hour, guys. So we're going to be stopping at 12:30 regardless. So let us rip through this. It's a really discrete area, but there's a lot to learn in a very short amount of time. So Carla, please take us away.
Sure, thank you. Look, thanks, Ian, and hello everyone and welcome. Look, unpaid work can take on so many different forms. We use so many different terms to describe unpaid work. Sometimes we call the workers volunteers, sometimes we call what they're doing work experience. The popular term at the moment amongst the entrepreneur and startup and small business community is this term internships. Work placements is another term that we use, traineeships sometimes, work trials is another one. Lots of different terms, all used to describe unpaid work. And look, sometimes there's a legitimate reason to engage in unpaid work. or there might be reasons around wanting to give a person a genuine opportunity to experience a particular job or work in a particular industry. It might be coming from a place of wanting to test someone's skill set before committing to engaging them. It might be to assist a not-for-profit organisation. There's a lot of different reasons why one might want to actually do unpaid work or have unpaid workers in your business. What I'm going to be focusing on today, though, is that it really doesn't matter what you decide you want to call the person or the work that they're doing. Characterising something as an internship won't help you if you don't meet the particular legal tests in place to determine whether or not this person is actually a legitimate employee who is entitled to receive minimum statutory entitlements under the Fair Work Act and any applicable modern award. So we'll come along to that point in a moment. So I think the next slide along talks about a particular case study. Now, I want to talk about a few different case studies, not just this one today, to sort of illustrate some of the key points. So recently you will have seen, perhaps in the media, Her Fashion Box, which is a fashion startup, is currently on the receiving end of some Fair Work Ombudsman proceedings, and I don't believe that court action has formally proceedings have been initiated, but there's still allegations at this point in time. Now, it's been alleged that this particular startup had an intern who was a tertiary qualified graphic designer who was working 2 days a week unpaid. It's been alleged by the Fair Work Ombudsman that in fact there's no genuine vocational placement in place, nor is there any legitimate basis for this work being unpaid. The allegation is that this particular intern is doing productive work and ought to be paid at least their statutory minimum entitlements. The other allegation in the course of this investigation was that 2 employees who were being paid by Her Fashion Box were not being paid their full statutory minimum entitlements. And my understanding from reading some of the Fair Work Ombudsman information on this is that those employees, whilst they were receiving a basic rate, were not receiving full entitlements, including loadings and penalties, public holidays, things of that nature that sometimes and often inadvertently do get missed, and it's important that they obviously don't get missed because it's unlawful if they are. So look, the reason that we're looking at this case study is to illustrate the point that because there was no genuine vocational placement in place here, and because there was an employment relationship established, the Fair Work Ombudsman has seen fit to start proceedings. And if ultimately held to full account and the allegations are substantiated, what will happen to Her Fashion Box is that not only will they be liable to pay the back pay, so what the employees would have earned, normally, but they may also be facing penalties and fines. And for a company, that's a significant amount. That's over, $50,000. And sometimes in certain circumstances, directors can receive personal fines as well. Just on that, and I just want to make the point that it's not only this particular startup that's, there's many businesses, big, medium, small, that have been investigated by the Fair Work Ombudsman and who have faced federal courts in relation to unpaid work and unpaid interns. In around June last year, actually, a Chinese media company, AIMG BQ, was fined $270,000 in relation to the non-payment and underpayment of 2 event coordinators and an event planner. Now, in that particular case, the federal court judge found that there were 180 hours of unpaid work that an intern engaged in organising events for this particular media company. Now, that was quite an extreme case. That particular company was also found not to be issuing pay slips and not to be meeting other basic parameters of employment. And in that particular circumstance, the director was actually fined personally or individually just over $8,000. So the lesson falling out of these sorts of cases is that there's only a very, very limited number of circumstances where you can get away with not paying someone for doing work, basically. There's only 2 unpaid work is whether or not it's lawful hinges on 2 things: whether or not there's an employment relationship and whether or not the arrangement involves a vocational placement. So if there's an employment relationship, then you need to pay that particular person, and it doesn't matter if you've called that person an intern. If they tick this criteria that you see in front of you on the slides, then chances are they are an employee and you do need to pay them. So it will be necessary to look at things like, how long is this arrangement on foot for? Generally speaking, the longer the arrangement, the more likely the person is to be an employee. The flip side of this is that for vocational placements and genuine training courses and things like that, they're generally for a finite period of time, or for, at the very least, a short term. So the longer the arrangement is on foot, the more likely it is that it's an employment relationship and that you will need to pay. Then you need to look at all the facts and circumstances, such as how significant is this arrangement to the business? So you need to ask yourself questions like, is this work that's normally, is the work being performed by the intern, is that work that would normally be performed by someone who's being paid? So the more integral the work is to the business, the more likely it is to be an employment relationship. You also need to ask yourself questions like, is the role the intern is taking on, is it more observational, like sitting back, observing, learning, or is it quite active and doing based? The more observational it is, and the less sort of productive and doing it is, then the more likely it is to be a genuine vocational placement. However,
I guess for startups and small businesses, just chiming in on that, for startups and small businesses, there is a lot of work to do, and I would imagine that there's a trap to be fallen into here, where you've got someone who's really eager to learn and working more than likely with the owners of the business pretty closely, and wanting and very keen to help out on stuff, and saying no and saying, look, this is not something you can kind of help me with. It'd be very tough for a small business owner, not to say, yeah, it would be great if you could do this or that and whatnot, which would I think start to fall into the other territory.
Yeah, look, that's right, and that sort of leads me to a sort of general point, which I think is really important to make here, which is just because a particular worker puts up their hand and says, look, I'm just really grateful for the opportunity. I've got nothing on my CV. This means the world to me. I'm happy to work for free. I'm happy to do anything. That's all well and good, but the legal risks still stand, and a person can't contract out of being an employee at law. So at the end of the day, as a business owner, it's incumbent on you. You're the one that's taking on the risk at the very least, go into unpaid work and unpaid internships with your eyes wide open about the risks. Because like I said, having an employee say, or having a worker say, I don't need to be paid, I'm just happy for the experience, won't mean that the Fair Work Ombudsman won't investigate you and won't potentially take you to court if they establish that there's a genuine employment relationship on foot. So,
and I guess that, yeah, exactly. And you were just about to say it. The buck stops with you as an employer, and unfortunately for small business owners, because we don't have normally the resources, the in-house counsel, contact frequently with an employment expert, because it's not necessarily income producing activity. A lot of small businesses fall foul of this stuff. And just coming back to the point about her fashion box, I've got no idea how the complaint came about, but it came, there was one instance that then opened up, the Pandora's box for further investigation. It was one intern. But the danger is, it's not just, for larger businesses where there's an instance of many unpaid interns. It seems as if the Fair Work Ombudsman will go after any one person that falls foul of this.
So, Ian, I think the relevant point there as well is that often with the larger organisations, they have quite a structured internship program.
Yep.
Yeah, so they've actually developed a training course that they roll out. And those larger organisations have the resources and the capacity to do those quite structured internship programs. Now, usually they will run for probably not more than 4 weeks. There will be structured compulsory training, and things of that nature. And in those circumstances, that's likely to meet, the Fair Work Act definition of a vocational placement, because there's a high level of meaningful skill development and training. That is so very different from putting someone on 1 or 2 days a week for an indefinite period of time, having them do your odd jobs and your admin, calling them an intern. That just won't fly. And and to a certain extent, look, small businesses and startups are a soft and easy target for the Fair Work Ombudsman. And the reason for that is because they, unfortunately, they do frequently fall foul of the law. And that's not because, they're trying to be dodgy or shady. It's literally just when you're in the throes of starting a new business, you're so very busy, you need all hands on deck, and sometimes the legal issues and the risks, they're not front and center for you. You just want to get your business being profitable and get it off to a flying start. So it's a balancing act like anything, and I think the point is this: if you are looking to have someone on board helping your business grow, and they are doing, genuine work that's actually helpful to your business, and you're not necessarily all about developing their skill set, then think about putting them on as a casual, think about paying them their standard casual rate, and just minimise your risk that way. If you are thinking about an unpaid internship, then before you actually onboard that person, my suggestion would be actually sit down and produce a structured internship program. That doesn't need to be a lot of work for you, but just a 1 to 2 page document that sets out the specific training that you will have the person do. So if push came to shove, you could satisfy a Fair Work Ombudsman that, look, I actually had this training program in place, through which I assisted to develop the skill set of this particular individual. And the arrangement was only on foot for 1 month, 2 months, or whatever the case may be. We're getting towards the end of our time slot here, and I just want to run through some key takeaways, some of which I've obviously already touched on. My first point would be just never never go into these sorts of arrangements assuming that the work can be unpaid, unless you are from a very big organisation, or unless we're talking about a state or territory or Commonwealth specific registered training program. Unpaid work is rarely lawful. So go into it being aware of the risks. Genuine internships are very much a two-way street. Someone is giving their free time and labour to you, but you need to very actively invest in them, almost to your detriment. It's all about them and not really about what you get out of it. It's not free work, basically. If in doubt, get informed and even think about getting some legal advice, or think about paying the basic entitlements. Look, there is a lot of really great information publicly available on the Fair Work Ombudsman website. There's fact sheets, stuff like that. Bear in mind, if you call the Fair Work Ombudsman, be careful about the information you disclose to them. You don't want to inadvertently trigger an investigation into your business, so think about whether or not you actually cold call them. But also bear in mind they can't give you legal advice either. They will very much be in favour of, if in doubt, pay. If you are paying people, that's fantastic, but get it right. There's been so many examples where these businesses that have these unpaid interns are also getting stung for basically underpaying their actual employees, because they're not paying loadings and public holidays and penalties and all of that kind of thing. So if you're going to pay, get it right. There's no point paying and not getting it right. Look, at the end of the day, these Fair Work investigations, they can really they can throw you out of kilter. They take up a lot of time. If you're a small business or a startup, you don't have time to be dealing with queries from a Fair Work investigator. They've got very broad powers, and look, at something that if you can, you would avoid having an investigation. The fines can be big. The current fines for a company are up to $54,000 per breach and $10,800 for an individual. So if you're a sole trader, $10,800 is what you would be up for. Not to mention the bad press and bad publicity. The Fair Work Ombudsman can actually still print your name, even if it's an allegation that's found to be untrue. So even just the whiff of guilt and bad press, even if you're ultimately found to be not guilty of the breach, it can still really damage your brand.
Good example of that is the 7-Eleven recent underpayment allegation. Can you imagine the business disruption and annoyance that would follow as a result of having something that big, and they've got the resources obviously to handle this type of thing. And I just couldn't imagine as a small business having to go through that process, let alone the stress on a business owner, while that's taking place. And then it sounds like the Fair Work Ombudsman is really starting to become more active in this area as well. And I imagine once it's almost the way that it's going at the moment, where some of these government authorities will start to have a bit more linkage with other government agencies in terms of information, and be able to investigate those things where they and start to pin down or focus their attention on certain areas, just like the Australian Tax Office does, with certain industries, and they say, we're going after these guys this month or this quarter, so as to kind of get the message out there that they are very active, and it sounds like it appears that even if it was a complaint that was made, they're going to be red hot on this stuff, and I imagine the Fair Work Ombudsman is going to be more active, in this area. So it is a matter of education. This is not common knowledge, and just like all those breaches of those sort of minor criminal breaches. It doesn't matter whether or not you necessarily knew you were breaking the law. It's not about what we call in law the mens rea. It's about whether there is a breach or not. It's a technical and that's the dangerous sort of area. It's a technical breach, and then the damages then follow. It doesn't come down to whether or not you kind of knew. Obviously, that may have an impact in terms of penalties or whatnot. But in terms of actual breaches, then it's really a strict kind of liability approach. That's right, isn't it, Carla?
Yeah, that's right. So intention is irrelevant. Look, at a penalties hearing, you can make any submissions that you want in your favour, and like I said, the fines are up to $54,000 and $10,800. That doesn't mean you'll cop the full 54. The court will consider a range of factors when handing down penalties, but if you breach the rules, you breach the rules. It doesn't matter if you're a good guy or a bad guy. If you breach, you breach, and you will have to face the consequences of that.
Great. Obviously not a great way to end the webinar, but this is the importance of it. And that's why we're doing this for you. Any questions that you might have, feel free to contact us. Here are the details on your screen, and if we can help out in any way, please give us a call. And if you want us to review any of your employment contracts to make sure that they're in accordance with the right legislation, paid in accordance with the right awards, etc., encourage you to pick up the phone and ask us. Obviously we're doing these webinars to show that we're not scary. We're both in plain clothes. We don't wear suits to the office with ties and all the rest. That's our kind of mantra, because we're real people, just like you guys. So we're going to be uploading this as well to Law in a Box. We haven't launched it yet, so actually this is the first time we've been speaking about it. And it's an exciting new product that we're going to be launching to the market, which provides all the legal information that you kind of need as much as we can across a range of different areas, but workplace being one of them. This will be in the workplace section. So if you go to progressivelegal.com.au and go to Law in a Box, you can have a look and see what we're building, which is a mixture of locked and unlocked content. And we've got an introductory offer there of $197 for a yearly subscription, and we'll start to build out a lot of this content, do case studies, articles, frequently asked questions, the webinars, videos, how-tos, etc. But you'll be hearing from us more in due course about that. All right, thanks very much for your time. Now I know we're 1 minute over, so we got to go. Have a good day, and if you've got a long weekend coming up, enjoy the Queen's birthday long weekend. Thanks everyone. Thanks, Carla.
Thank you.